speaking of the Bill of Rights here, I always read the preamble for a reason because Congress wrote this after the ratification of the Constitution because they wanted to make sure that there was no confusion and clarity. And the reason I bring this up all the time is because it just shows how important your amendments are. Okay, so I'm going to read this to you. Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, 1789. The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire, in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and is extending the ground of public confidence in the government will best ensure the beneficent ends, did I say it right, of its institution. Okay? I'm a 50-cent word man. You're a $1.50 word man. So he helped me on that one to say it properly. And Ross, you got the show, brother. The Sixth Amendment. Tell us about it. Break it down. How does it apply? Why is it so important? Why should people know it? And why should people always be aware of that preamble to understand how important these rights are?
So the Sixth Amendment's going to be the criminal defense lawyer's tackle box. Okay? That's a good way to put it for trial.
Okay.
Okay, a criminal defense trial lawyer's tackle box. Okay, it's going to give you a bunch of the rights that a criminal defendant is entitled to at trial. Okay, and there are actually several here. All right, I've tried to break it down into 5. Okay, with some subsets to make it easier to grasp. But let's just go ahead and read it real quick. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Okay, and so
it's chock full of rights there, isn't it?
It is. It's got a lot there, and some of them may not even stand out to you, but they're important when you look at the purpose of the right. And so let's break it down into 5. We're going to say trial, notice, confront, witnesses, compulsory process, and attorney for your defense. Okay, but it really goes in. There's a lot more there, and if you wanted to break it down into each individual right, you'd have way more than 5. Okay, but let's start with trial. Well, we know we've got a right to the trial, but we got a right to a public trial. We got a right to a speedy trial. We've got a right to a jury trial. Not just a jury trial, but a jury trial of made up of impartial people. Okay? There's more rights here. From a district within the state where the crime is committed. Okay? And that's because we don't want, excuse me, I may offend some people. We don't want liberals from California, right, being juries on a conservative case in Alabama. Okay? Because the environments are not the same.
That's right.
The people, the local conduct.
It's almost like family. It's, but out of my family business. Basically.
And there's things that are acceptable in different parts of America's big and great. It's got so many different kinds of cultures. It's got so many different kinds of people, and so many different kinds of laws that, what's acceptable in one part of the country is oftentimes not acceptable in another part of the country. Even though we are all Americans and we all do have this general sense of what is acceptable and what is not, there are very specific things that could really upset one area of a community that won't upset another area of a community in a different part of the country. So it's important that it be drawn from that specific district within that specific state. That makes sure that the jury is impartial.
Right.
Okay, and impartiality is a big thing. You want to make sure that you're getting peers that understand your case and they're going to be fair to you. And a lot of times my girlfriend this morning was watching the show about the funeral director in East Texas, Carthage, that murdered that lady and put her in the freezer. But he was such a good guy, and she was so evil, and everybody in the community actually probably would have found not guilty,
yeah,
because she was one of those. It was one of those deserved killing defenses,
right? Yeah.
Good killing defenses. And so the prosecutor, it's kind of one of those odd deals where actually the prosecutor was trying to change venue. because it was unfair to him. He couldn't get a guilty verdict because everybody hated that lady.
That's like that movie, A Time to Kill, man. There's a time to kill, and there's a time not to kill.
So, I mean, it is important to have an impartial jury on your side. I mean, that's the whole point. That's the whole point in jury selection. I think one of my favorite things I used to get a kick out of. I really can't pull it off, but Clyde Chandler used to say, "I'm not looking for a fair jury. I'm looking for a jury who's going to listen to my case." Okay, and so an impartial jury is somebody who's not going to be biased against you, somebody who's not going to let prejudice get in the way of listening to your case. And if I can get to a couple stories, they're good illustrations of that.
Doesn't this all stem from back in the day when the founding fathers wrote this, come from England, and how people would be taken prisoner and kept in cells for weeks on end without any fair trial? That's why it's so precious, this amendment, to make sure that doesn't happen to us here in this new country.
So that's getting into the notice portion, and we actually have a special provisions in Texas about you can't be held in jail for more than so many days on certain level. It's like a Class B, Class A misdemeanors, state jail felony, first, second, and third degree felony. Each one of those has a different time period because of the seriousness of the offense. But in Texas, we require you within so many days, right, to be notified of exactly what the charges are and to be presented with the indictment, or the prosecutors have to let you out.
Good job.
Okay, and that stems from, I told that story specifically to Texas because that one actually has roots in the fact when Stephen F. Austin went down to Mexico to try to petition with Santa Anna, and Santa Anna was at that time already preparing that he was already going to come and try to quell some of the rebellion that was going on in Texas. And so instead of listening to Stephen F. Austin petition about certain locations, he just put him in jail. Mm-hmm. Didn't tell him what he was being put in jail for. He was put in jail for months, okay, and just left there, just to rot essentially, and eventually just was let out, and he did make his way back to Texas, but it was totally unfair, gave no notice, and so you can't do that. It's a violation of your due process rights. I mean, you can't just put somebody in jail without letting them know what they're there for, and without giving them an opportunity to have access to counsel, without access to a way to get their freedom back.
That's a great example. Yeah.
And so, but sometimes things that don't stand out to people either. Why do you think we need public trials?
Because you don't want dirty tricks being done behind the scenes. You want it to be out in the open so everybody knows what's going on. It's legit, it's fair, and there's no trickery.
Okay, that's all. You gave several examples there, which are good. We had the Spanish Inquisition. We had the Star Chamber. We had, I don't even know how to pronounce it. I've heard the different names. Lettre de cachet. Okay, something like that.
Watch it, man.
It was another French device for allowing secret proceedings. Okay, to challenge people. Star Chamber is one of the worst. I've talked about it several times on here about the things that they did to bring challengers of the crown, bring those folks in and bring them in the Star Chamber, and it was essentially another Spanish Inquisition. It was another way to do an Inquisition. It was another way to get your political challengers out of the way.
That's right.
Okay, and we don't want that. And everything that you just said is right. It needs to be public. It needs to be out in the open. So
today is March 23rd. The time is 10:35. I was right. Mark that in your calendars. You're not going to have that often. That I'm right. That's a joke.
Okay. I got you.
I'm sorry. Go ahead.
No, so it's public. It's a public trial, and it keeps the government honest.
Yes.
That's what it does, and it's so fundamental, right? A lot of times it's not mentioned that much, but it's so fundamental. The court actually analyzes the public trial clause section, okay, with the First Amendment.
How many times do you know people? I know this happens to me. I cringe at the sound of it's going to be a closed door meeting. It's going to be no media allowed. I'm thinking, why? Why can't we go in there and see what's the big deal?
Sometimes those are going to be permissible in cases of like child sexual assault, like when they're going to be bringing out some really hurtful information. Other times, juveniles. There's going to be some juvenile cases. There's going to be other trials maybe where there's an ongoing conspiracy that still the government is still working, right? But they've got this half all worked out and they're prosecuting this half. And so maybe they don't want all of the information to come out because they don't want other people learning about, right, what the government's about to do strategy-wise in an ongoing investigation. And so,
Well, if you say it's okay, then I'll take your word for it.
but those have to be very narrow, what we would call in the legal field is narrowly tailored. Okay, they have to be just enough to cover the stuff that we don't want everybody to hear, right? And that's it. It can't cover more stuff. Like there was a famous case. It was a 7-day secret trial when they only played like 2.5 days of, or maybe even less than that. I think it was even less than that. It may have been only hours worth of the confidential stuff. And the court said, "Nah, you can't do that. It needs to be, if it's 2 hours of confidential stuff, then okay, 2 hours needs to be made secret, not the whole week."
Okay.
So it's important to keep a check on the government. Speedy. I'm going to ask you, what do you think? Why we have a speedy trial? What is the need for having speedy?
It's kind of basically what I said earlier. You don't want to, if you're going to try to convict somebody of a crime, get it done and over with. Why torment? Keep a person in jail if he ends up being innocent at the end. Why keep him in there for so long? If he's being accused, get the people, get the trial, get it done with.
But haven't you heard me on here before talk about anything that's not a loss is a win from a criminal defense standpoint? And some of the best defenses are delay. delay. So why would we want a speedy trial? I mean, it's kind of counterintuitive, right? We're trying to push it back. We're trying to let the defendant get more money so he can fund this thing. We're trying to get the defendant more money so he can have time to investigate. We're trying to have more time so that we can have the attorney really prepare for the case and find a defense.
Well, wait, what are we talking about? Speedy trial in the sense you're in the courtroom, you want it fast in the courtroom, or everything proceeding up to that day and time?
The whole process. So what? And then too, where does the speediness come into? Because you already have the statute of limitations.
Well, it all depends.
The government's already going to have a limitations period to bring a case.
It all depends if you're sitting in a jail cell or not. If you're out, yeah, okay.
Bingo.
Delay as much as you want.
That's a big one, right? We don't want somebody sitting in jail, languishing in jail, right, without any means to be able to do anything about it. They need to either, if they're going to be languishing in jail, we need to have a process to make sure that they actually get heard, so that if they're not guilty, they don't sit in jail. And another thing is, what about witnesses and evidence? Over time, if the government could just delay forever,
people forget.
People die. Evidence disintegrates. Evidence disappears a lot of times. Right? People move. Yes, you do have compulsory process. This goes into that. In a civil case, you're going to be limited, 150 miles. You're not going to be able to go past that to subpoena people. Okay? In a criminal case, you got nationwide authority. You can go anywhere in the United States, right, and get your witnesses. Okay? And so, yes, people move, but it still makes it harder, no doubt, right?
Absolutely.
Even if I can go anywhere, you would agree with me that it'd be a whole lot harder to find a witness that moved to Alaska than if they just moved to Rockdale.
Absolutely.
So we got to have this speediness element, or the government could just delay in hopes that something would happen in their favor, and then they could bring the trial.
And then they win.
Right? Yeah, exactly. And so a lot of times, though, they're not going to give this right to you. They're not going to let me delay and acquiesce, like agree with the state. Yeah, delay, and use that as a way to, and then when the delay works out not in my favor, then use that as a way to, right, get the case thrown out. Okay, so the defendant doesn't necessarily have to bring an action to speed up the trial, but he can't be a party to why there's been such a delay that maybe this section, this clause, right, could be used to his benefit. So we have the two biggest rights, and so before we get into these, we've talked about Brewer versus Williams, and that was it's one of my favorite cases, simply for just because of just everything. It's such a powerful story on both ends, where the man in the 1970s escapes from a mental institution. Miss Pamela Powers was a young girl. I think she was 7 years old, but I could be wrong on the exact age. But it was a small, young girl, up and coming, very sweet. Just one of those stories where she is everything that parents and grandparents want their grandchild to be. Okay, and just a wonderful young girl, and was going at a play day, sort of at some sort of a facility, and that's happened to be where Mr. Williams, the escaped mental institution uh, uh, person who was in the institution, the defendant in this case that gets off. Okay, Mr. Williams, he happened to go to the same facility when he's wandering around after he escaped from the mental institution. Okay, and so he sees Pamela Powers and he takes her, and he essentially kills her, even puts her in a trunk, right? Leaves the town and buries her somewhere out in the wilderness. Now, Mr. Williams had been a preacher, right? He was very, there's probably a backstory to why he developed a mental illness, but he was a preacher and somebody who was very religious. He was very sensitive and emotional towards religion. And so eventually he comes to have like what we would call maybe a moment of clarity and realizes that what he's done to this little girl. And he calls a lawyer and tells him what he's done. He says, I don't know why I have this problem, but I have it, and I need to turn myself in, and I need to make amends for what's been done, and I need to, I just need help doing this. And so the lawyer arranges, and the authorities are going crazy, right? They're trying to find the person who kidnapped this little girl, and they don't know what's happened to her. And then the lawyer calls in and says, look, Mr. Williams calls me. He wants to turn himself in. He wants to talk about things, but under no circumstances are you guys to talk about it here, because he had traveled to a different town, a different location, and before we can talk about anything, I want you guys, talking to the police, I want you guys to make sure that you bring him back here where you can have me present before he speaks with anybody. And the police agree. They even agree. They get the prosecutor involved. The prosecutor agrees no cops will question him. Nobody will question him until he gets back to this town. The police, the police chiefs are warned again. Again, do not talk to him. Do not ask him any questions. Do not do anything, right, that would jeopardize the case. Do not do anything that would talk about, right, the crime without his lawyer present. That means do not talk to him at all until you get back to where his lawyer is in this other town. Okay. And they continue to stress this point. This was made more than once, more than twice, more than 3 times. The police knew the deal. They agreed not to question him. Well, Officer Detective Lemming knows Mr. Williams, or he knows about Mr. Williams, and he knows that Mr. Williams has these sensitive predilections. He's already subject to being very emotional, right, with a religious sentiment. And so on the way back to this other town to meet the lawyer, Detective Lemming is the one that's tasked with the duty to drive Mr. Williams back to his lawyer. And so during that drive, and it's a several-hour drive, right, Detective Lemming thinks that he's clever, and so instead of asking questions, he just starts playing on his emotion. It would really be good to have for the family to be able to bury this little girl, like a good Christian family would want, and like a good Christian would deserve. And starts talking about things about how the spirit may not be able to go without a proper burial with the body, and talks about how important it is from a religious standpoint to have, right, the memorial service and to have the religious ceremony with the burial. And it's really just, it'd be really good for you to tell us where that, if he's maybe not like that even, maybe it's just, it'd be really good if, somebody would tell us where the body is so that we could have this burial. And they wanted the body, right, because they needed evidence, right? A lot of times, they'll say that having the body is necessary for the conviction. That's not necessarily true, but right, it definitely helps. Okay, it's a big part of it. And so yes, eventually he gets Mr. Williams to tell him where the little girl's body is, and they go there and they dig up her body, and this was all without a lawyer. And it goes to trial, and of course she's convicted, and it goes up to appeal, and they appeal it all the way to the United States Supreme Court. And it was overturned on the appellate level because they violated his Sixth Amendment right to counsel. Okay, and I know what you guys are thinking. Like, there's nothing wrong with this. This guy deserved what he got. This guy, there's nothing. But the court said no. Right? The police knew what they were doing. The police knew they were violating his Sixth Amendment rights. The police knew that this gentleman had constitutional rights and intentionally And even though they agreed over and over and over again, and it was made known to them, they simply ignored the constitutional requirements and just totally squashed them based on police detective motivations. Mm-hmm. And so, there was this huge dissent, and people were dissenting generally. People were upset by this, and then it was I tell this part. It was Justice Stevens that said, right, nothing we write can bring that little girl back. Nothing we write can bring that little girl back. But what we do write has implications for generations to come, future generations. And I think that there was Justice Marshall wrote, the dissenters have, I believe, lost sight of the fundamental constitutional backbone of our criminal law. They seem to think that Detective Leeming's actions were perfectly proper, indeed laudable examples of good police work. In my view, good police work is something far different from catching the criminal at any price. It is equally important that the police, as guardians of the law, fulfill their responsibility to obey its commands scrupulously. In the end, life and liberty can be as much endangered from illegal methods used to convict those thought to be criminals as from the actual criminals themselves. And then he goes on to quote a very famous quote, and it says, "For good or for ill, it teaches the whole people by its example, that is, the government. And crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself, and it invites anarchy."
Yep.
And so they broke the law clearly here, and it was important for this man who was trying to do the right thing, even though he had done a bad thing, to come to justice. But he still deserved the process.
So what was his conclusion? What ever happened to this guy?
In the end, there was another case. There's another famous case, and it actually gave an exception to the Sixth and Fourth Amendments, right? And that is inevitable discovery. At the same time, right? There was other evidence about where the girl's body could be found from another completely different department, and so they were already en route to go get the little girl.
So fortunately, because although the one detective did something outside of the proper law, they were able to utilize, and throw that out, they were able to utilize another
later on. Yes.
So we were fortunate on that.
In a second,
but I'll tell you, everything you said, Ross, I cannot deny. I will not say I don't agree, because I do. I think the law is so precious. You've got to protect it, and if there is a flaw in the law, then we do the process to get it corrected. But until such point in time, if you start screwing with the law, just like you said, then it becomes worthless.
Right. And so in this case, too, it illustrates what exactly is the lawyer requirement. So as soon as you say, I want a lawyer, interrogations have to cease. And I told the folks that were listening in last week that when we talked about the Fifth Amendment, we would talk about the interrogation aspect. It's got to be custody and interrogation. And so we spoke during the Fifth Amendment whether or not a seizure is custody and whether custody was a seizure. And we said that custody is definitely a seizure, but not all seizures are custody.
Can I be ignorant here? Help me clarify. You're being detained, you're into custody, and seizure.
So a detention is a seizure. Okay, any kind of submission to a show of authority, any kind of time you stop after being asked to stop by the police, that's going to be a detention, probably. I mean, 90-something% of the cases.
Sometimes you see people say, "Am I being detained?" And then an officer said, "Well, no, but we want to."
Right, and then so if they say that, I'd leave. I'd turn around and walk off. Okay, we'll see you later. Okay, and so if they're going to detain you, then they need to detain you, and if they're going to put you in custody, that's when you're going to be interrogated. That's also when Miranda for the Fifth Amendment is going to apply. Is when you're in custody and you're being interrogated. So this case really gives us a good example about what can be interrogation. So it was thrown out because he didn't ask him any questions.
No, he did not.
He didn't ask Mr. Williams any questions.
But he spoke in a manner that made him spill his guts.
But yes, and so it was calculated. What the phrase is going to be? It was calculated to elicit an incriminating response.
Yeah.
Okay, it was calculated to elicit an incriminating response.
But I do commend the officer. I do commend him. That was very. He's sharp. He's thinking.
He's sharp. And
however,
what else about Detective Leeming, I think, is a big A plus for him? He was honest. He didn't lie about anything that he did. When they called him at trial and tried to get this case thrown out for that, he didn't lie about any of it. He straight up said, yeah, I did that. This is what I did.
Hoping probably that it's a loophole that will be overlooked and he can get this guy convicted.
Probably, but it was just between him and Mr. Williams. He could have said whatever he wanted to say.
That's right, yeah.
And so
he admitted it. Yeah.
Big kudos to the police in this instance for being honest on the stand, because I can tell you, there's at least some police officers out there, if not a lot, that
doesn't this kind of go like
probably wouldn't have been.
I love
honest.
Caesar, but I love Rome more. Isn't that kind of the same thing? We love how this is happening to catch a criminal, but I love Rome more, meaning I love
Correct.
to preserve the law, to keep it intact, because like you just said before, if that gets corrupt, then everything gets corrupt.
I think that's a really good analogy. Okay, so it's
10:52 on March 23rd. Matt said something good again.
And so we have, I mean, this is just, it's just one of those example cases. And so I love to bring this example up and ask jurors, if they were in the judges' positions on the Supreme Court, would they have been able to do this? And if they say, no, I don't, that's somebody I don't want on my jury. That's somebody who doesn't love Rome more. They would rather see the bad guy go to jail.
All right, give me 1 second. We got a question here. Do we get anything from Delicious Janae? Guys?
Got it, but we don't know what it is.
You got it? Okay. We're going to have to wrap it up. Ross, can you summarize all the Sixth Amendment here real quick?
Remember, we want a fair trial, okay? And a lot of the times that means the public trial, a speedy trial. It means the location of the trial, and it means the jury, and it means the location of where the jury comes from. It also protects notice. We got to have notice of what we're being accused of and why we're being accused of that, including the facts of the case. We want to be able to confront our witnesses, which we didn't even get to, right? And that based on hearsay. We don't want hearsay that's out there, just what somebody else said, without being able to confront that person and see where they're getting their information. Okay, and this is probably one of the most important rights out there, and I'm sorry we didn't get to it.
Well, let's do a Sixth Amendment Part B then.
Okay, I think that would be great.
Okay, and I don't know what Rick's schedule is. If he has to come in this upcoming Saturday, we'll do that and then follow up again on it. Otherwise, if not, I can postpone the 7th and do a Sixth Amendment Part B.
That would be great. I'd love to do that.
Okay.
And then compulsory process. We have a right to go get our witnesses that are going to help our case.
This is a very important one, ladies and gentlemen.
And
we need to go over
we have a right to an attorney. Okay, you have a right to an attorney, and it's just a huge right, as we can see from Brewer versus Williams.
Very good. Tell everybody who you are, how to get a hold of you.
Benton Ross Watson. We love questions about the show. We love comments on the show. You can email me at benton@watson.legal. That's benton@watson.legal. If you got, please, a lot of times I get an email without a phone number. Leave your phone number so I can call you back. If you need to call me, it's 254-605-4140. That's 254-605-4140. Leave a message. Me or Sonia or I will get back to you if you want to schedule an appointment here in Cameron, or even in Brazos County or Harris County. Please do call that number, or just come see us down here in Cameron at 105 East Main Street. 105 East Main Street here in Cameron, right across the street from the courthouse. Big milk cow on the side. You can't miss it.
Sounds great. RespectForYou.com. Copley & Dodd Krebs Law Firm sponsoring this long segment. We can't thank them enough, and all our sponsors as well. Ross, as always, it's a pleasure. Thank you very much, sir.
Thank you, man.
And maybe we'll see you next week. I'll talk to Rick about it.